Lawyers have read it. What was your hold it moment where you knew you would win? Story 1. I trapped a defendant pretty badly one time. He testified in a deposition he had a green arrow for his left turn and that my client ran the red. Unfortunately for him, the additional turn lane arrow was installed 2 months after the crash. Case settled for policy limits a week later. Story 2. It wasn't at trial, but during a deposition on a case where 2 former employees decided to start their own company in a very niche market, but decided to make their plans on company laptops they unsuccessfully tried to brick. One of the defendants was the one being deposed. She said she, quote, to a higher power than the company. When pressed on what that meant, she said herself. That got reused prominently at trial. Story 3. I was reviewing the transcript of an interview with a child. The child made incriminating statements against my client. At one point, when discussing the allegations, the child used an odd word, but I didn't think much of it. A few days later, I was watching a video of the child interacting with their grandmother, who hates my client, from about a week before that interview. The grandmother used the exact same odd word, in the exact context the child later used it. At that moment, it became clear the child had been coached. It was the first real aha moment of my career. Story 4. I worked on a case involving defective processors. In discovery, we got emails from the defendant's engineers that had worked on the processors. They were in an Asian country, but the emails were in English because they were going to U.S. executives. One of the more senior engineers basically laid out the exact defect we were suing over, explaining what the problem was and why it was their fault, and finishing with, "This is big problem, we ship crap to customer." Needless to say, we hit them over the head with that in mediation, and they settled shortly after. Story 5. It was my 3rd month of practice. I was in family law at the time, representing mom in a petition for a restraining order against boyfriend/dad. At issue in the broader case was child visitation, custody, support, etc., but today's hearing was just on the restraining order. We had pretty good facts, but it was mostly based on testimony of the parties. My client was way more reputable as a witness, so I was feeling confident. 10 minutes before the hearing, my client shows up. I give her a last-minute prep on what to expect, and then she says, "I'm glad I'm going through with this. I can't deal with it anymore, and he's just getting worse." To top it off, he left me a drunken, ranting voicemail on Saturday. "You have your phone with you?" "Yes." We play the voicemail, and it's a full 2 minutes of ex-boyfriend screaming things like, "I should have done you in when we were together. You were always such a witch. I hope you burned to death in a fire." I didn't have time to ask her why she hadn't said anything to me about the voicemail before the bailiff called our case. We sit. The judge asks if either side has additional evidence, and I ask for permission to play the voicemail. Ex-boyfriend, who didn't have an attorney, didn't object, so I played the whole nasty 2-minute rant in open court. Judge goes, "We're going to take a brief recess before I issue my ruling. If the parties want to meet and confer in the hall, they are welcome to." Boyfriend knew he was screwed. We settled the whole damn case then and there. My client got her wish list in terms of custody, supervised visitation, child support, plus the restraining order, to boot. Story 6. I'm a trial lawyer. I have a ton of these. My favorite was probably a driving under the influence case, where the cop was in a Buffalo Wild Wings with my client watching a fight. The cop was standing at the bar in full uniform. Then, when my client walked by him to leave, followed him out. Client was only actually going to his car to grab his phone charger, because he was going home with the bartender. He hadn't even closed his tab yet. Cop arrested him and charged him with driving under the influence for opening his car door, then fabricated this story for his report about how client got in car, turned it on, and began to pull out of the space to leave the parking lot. He also denied being inside the Buffalo Wild Wings, on the stand, under oath, to my face. Surprise! I talked to the bartender at Buffalo Wild Wings and got the security tape. It very clearly, surprisingly good quality, don't try to steal from a Buffalo Wild Wings, by the way, showed cops standing at the bar, watching my client walk out the front door, then follow him 30 seconds later. Parking lot cam also showed client barely touched the door handle before cops stopped him. Story 7. It was day 2 of a child custody modification trial. The opposition and her attorney were and are batshit crazy. Their allegations were so weak that I told my guy, screw it, let's go for custody ourselves. I'm cross-examining mom about her proposed custody plan for dad in some detail, and I ask her, would you accept this for yourself? She snaps back, absolutely not. I ask why not? Because I'm a mother. To his credit, my guy kept a straight face the entire trial and never once got pissy. Her petition was denied outright. Ours was accepted by the court. If the mom or her lawyer hadn't been such pains to deal with, my guy probably would have agreed to some small reductions in his custody just to keep the peace. Instead, the judge gave us nearly everything we asked for. Story 8. I had a ton of these when I used to do family law. Off the top of my head, my client's husband was alleging she had been high and nude in public. As I'm crossing him, I get him to admit that she was, in fact, changing out of her bathing suit at the beach and covered by a towel at all times. He says, well, she was naked, under the towel. I come back with, just like you're naked under your clothes right now? Even the judge chuckled. Story 9. I had a client charged with battery. The alleged victim didn't really support the prosecution's case, and in any event was reluctant to testify. They still had another witness, though, and she said that my client was hitting the alleged victim, so it wasn't looking great. The prosecutor and I were talking before court started, hanging out by the courtroom doors, when the witness walked in. She looked right at my client, who was sitting not 5 feet from me, then scanned the room and said, "Where is client name?" The prosecutor and I looked at each other for a minute, and then he said he needed to check on something. When I saw him a few minutes later, he told me he was dismissing the case. Story 10. I was testifying for the defense. A young man had been arrested for assaulting a police officer, allegedly throwing bottles during some unrest in Oakland, following the verdict in the trial for the cop who shot Oscar Green in the back on the Bay Area Rapid Transit platform. I had been there filming stuff, caught his arrest on video, and his brother found my footage on YouTube and asked me to testify. I had only seen bottles being thrown from this one corner of a parking lot, from behind me, with the bottles flying over my shoulder. The defendant was in a group in front of me. On the stand, the prosecutor seemed to think I knew the defendant and was there basically committing perjury on his behalf. I explained why I had been there that night, that I had never seen this guy before, hadn't been coached by the defense, and hadn't been paid other than a small amount for my travel and time. Finally, exasperated after much back and forth, the prosecutor says, "Well, if you don't know the defendant, then why are you here testifying for him?" I thought for a moment and said, "I guess I just wouldn't want an innocent man to get convicted for a crime he didn't commit." He got visibly flustered and quickly moved on, trying to insinuate that if you're looking at a group of random people, and one of them throws something, you will naturally fixate your attention on that person. But because nobody in that group threw anything, there was nothing to notice in the first place. It looked like the police just grabbed him at random. They rested. The defense attorney bought me lunch down the street, and then he got a call from his colleague that the jury took all of 10 minutes to return a not guilty verdict on the assault charge. They said my response was legendary, though, and that no attorney should ever ask a question they don't already know the answer to. This guy just seemed to have a narrative about a prior relationship to the defendant that he assumed was accurate, and was trying to call my credibility into question. Story 11. During a civil case involving a slip and fall at a grocery store, the plaintiff claimed severe back injuries that left them unable to work. They described constant pain and inability to lift anything heavy. During discovery, I requested their social media records, which they claimed didn't exist. A quick check by my paralegal found their public Instagram, where they'd posted videos of themselves dancing at a wedding 2 weeks after the alleged injury, including one where they lifted their partner overhead. I introduced the video in court, and the plaintiff's attorney's face went pale. The judge didn't even need to deliberate. Long case dismissed. Story 12. I was defending a client accused of shoplifting high-end electronics. The store manager testified that my client was caught on camera stuffing items into a backpack. I asked to see the footage in discovery, and they provided a grainy video with no clear face. During cross-examination, I got the manager to admit the store's cameras were old and often blurry. Then I presented my client's receipt for a similar but cheaper item purchased that day, which the manager hadn't checked. The prosecution's case crumbled when I pointed out their thief was just a customer with a legal purchase. Charges dropped. Story 13. In a custody dispute, the mother claimed my client, the father, was unfit because he was always drunk. Her evidence was shaky. Just her word and one blurry photo of him holding a beer at a barbecue. During her deposition, I asked about her own habits. She bragged about hosting, quote, wine nights every weekend, claiming it was classy, not like his drinking. I subpoenaed her credit card records, which showed hundreds of dollars spent monthly on liquor stores. When I presented this in court, her credibility tanked, and my client got joint custody. Story 14. I represented a small business sued by a competitor for trademark infringement. The plaintiff claimed our logo was too similar to theirs. During discovery, I found an old marketing email from the plaintiff's company, sent years before our client even existed, where they used a logo nearly identical to ours. I showed it to their attorney in mediation, pointing out their own prior use invalidated their claim. They dropped the suit the next day to avoid embarrassment in court. Story 15. In a criminal case, my client was charged with vandalism for allegedly spray painting a building. The prosecution's key witness, a security guard, swore he saw my client do it. On cross-examination, I asked about the lighting conditions that night. He insisted it was bright as day due to street lights. I pulled up city records showing the street lights in that area had been out for maintenance that week. The guard stammered, and the judge looked skeptical. The case was dismissed for lack of reliable testimony. Story 16. I was handling a wrongful termination case where the employer claimed my client was fired for consistent tardiness. They provided a log of clock-in times showing my client was late 20 times in a month. During discovery, I requested the raw data from their timekeeping system. Buried in the metadata was evidence the employer had altered the timestamps after the fact to exaggerate the tardiness. I confronted their human resources manager with this in court, and they couldn't explain it. We settled for a hefty sum before the judge ruled. Story 17. In a personal injury case, the plaintiff claimed my client's delivery truck hit them, causing permanent leg damage. They had medical records and a dramatic limp in court. I subpoenaed traffic cam footage from the intersection where the accident supposedly happened. The footage showed no collision, just the plaintiff jaywalking and tripping on a curb. When I played the video, their attorney tried to object, but the judge overruled. The case was thrown out, and the plaintiff faced perjury questions. Story 18. I defended a tenant accused of damaging a rental property. The landlord claimed my client trashed the place before moving out, presenting photos of broken fixtures. During the trial, I asked the landlord when the photos were taken. He said right after the tenant left. I pulled up the property's listing on a rental site, posted a week later, showing the same fixtures intact. The landlord's face froze when I showed the screenshots. The judge ruled in our favor, no damages awarded. Story 19. In a fraud case, my client was accused of forging signatures on a contract. The plaintiff's lawyer waved around a document they claimed my client signed without permission. I had my client's phone records pulled, which showed they were in another state on the date the contract was supposedly signed. I also got an expert to analyze the signature, which didn't match my client's. When I presented both in court, the plaintiff's lawyer started backpedaling, and the case was dismissed. Story 20. I was in a divorce case where the husband claimed he had no assets to split, saying he was broke. His wife, my client, suspected he was hiding money. During discovery, I requested bank statements from an offshore account he hadn't disclosed. He claimed it didn't exist, but a slip in his deposition mentioned a, quote, consulting fee wired abroad. I traced it to a hidden account with 6 figures. When I showed the statements in court, he admitted to lying. My client got a fair share of the assets. Story 21. I had client whose $60,000 car was ruined by a shop that put in the wrong oil. We couldn't prove it at first, the engine blew up, oil leaked out, and evidence was lost. I subpoenaed their bank records, figured out they bought their oil from Costco. Called Costco and got their prices for the last 2 years. I then worked out the amounts they were spending, did some backhand math, and showed based on the values it was impossible they had ever bought the right oil. They settled in full immediately. Story 22. Told this story a few years back, but everything old is new again. My brother is a divorce attorney. His most memorable case, he was representing a guy in a divorce custody battle who was accused of horrific child abuse. Very graphic, very detailed depositions from the young kids against daddy. Things look grim. Then my brother notices the deposition transcript, done by social workers under oath, contains a question at the end from one of the kids, "Did I hit my marks?" My brother had previously tried to make it as an actor in Hollywood right out of high school, failing miserably, and decided to go into law, an altogether different form of acting. He wonders how little kids know about acting jargon. Subpoenas the wife's personal checking account during discovery. Sure enough, acting lessons. Deposes an extremely sketchy acting coach, and panicked coach quickly coughs up digital versatile discs of practice interrogations with the kids. Hours of coaching the kids on exactly what imaginary things to say about daddy. He says it was his one and only Perry Mason moment in 20-plus years of practice, and dad got sole custody of the kids. Story 23. Had a client accused of leading the cops on a high-speed chase. The cop on the stand estimated he was going 90 miles per hour, but never actually clocked him. Then the cop identified where the chase started with me, and where it ended. It lasted about 2 miles. Then we went through his log of when it started and when it ended, about 3.5 minutes. Once you walk through the math on that, the average speed of this chase was 35 miles per hour. Client got acquitted really quickly after that. Story 24. I was suing a landlord who failed to make serious repairs in order to force the tenant out. The hard part is proving bad intent instead of mere idiocy, so you get higher damages. Code enforcement was involved, so I request those records. The landlord left a voicemail to the enforcement department saying to hold off on the fines. They will make the repairs as soon as the tenant is forced out. That was an easy case. Story 25. I was representing mom in a bitter custody fight. Dad wanted full custody and argued mom was an unfit parent. Mom wanted full custody because dad had a history of domestic violence towards her and the kids. Dad's lawyer was doing a good job of painting her in a bad light during his cross-examination, and I was starting to get worried. His lawyer brought a close family friend as a character witness for dad, who said the usual nice things about dad. Then he said something about them owning chickens. I thought that was odd, so I asked more questions. I was able to get the friend to spill the beans that the dad owned chickens for illegal cockfighting, and he'd take his minor children to these cockfights, and when the children were acting up, he'd punish them by forcing them to feed the chickens, during which they would get pecked and scratched by the chickens. And obviously the children were terrified of those chickens. I could see the color draining from dad's lawyer's face. Mom got full custody. Story 26. This is so petty. I've had much bigger moments, but because of the character of the other side, this will always be my favorite. Doing a boundary dispute, a squabble over what was essentially a few inches of land. The opposing side was a lawyer and an absolute jerk. He was acting for himself. The whole "a lawyer who acts for himself has a fool for a client" thing was bang on for him. But he was a deeply unpleasant guy, a bully who thought that he was the smartest guy in the room. Part of his case hinged on wheelie bins and how, prior to the boundary having been moved, there wasn't space to store a full-size bin beside the house. The fact you now could meant clearly the boundary must have moved. That was the extent of his evidence. It really was thin stuff. During the actual trial, he pulled a fast one by suddenly producing an old aerial photo, ostensibly to show the boundary at the front of the property had also moved. A fast one. Because you have to disclose stuff like that in advance, you can't just sit on something relevant and then suddenly whip it out at trial with a flourish. Story 27. A woman was charged with possession of a large amount of substances. Her boyfriend was a known, big-time substance dealer with a long list of priors. Her story was that 4 officers, A, B, C, D, came up to her outside her home and demanded to know where boyfriend was. They wanted all sorts of information about boyfriend and his associates. When she refused to tell them anything, she says Officer A threatened her, including pulling out his gun and pointing it at her. She also indicated that Officer A was wearing street clothes while B, C, and D were in uniform. Officers claim she gave them permission to search her home, where they found the substances. She says she never gave them any such permission, and they planted/pretended to find the substances. Officer A, it turns out, had been in the newspaper shortly before the case went to trial for various serious incidents of abuse and corruption. The prosecution naturally assumes this woman is lying and simply trying to take advantage of the media publicity. At trial, B, C, and D testify that they were there with Officer E, not A. Once the defense theory developed a bit, the prosecutor offered into evidence a handwritten schedule logbook thing that listed which officers were working on each day, to show that Officer A wasn't even scheduled to work that day. There were various reasons this log might not have been admissible, and it was never disclosed to the defense until right before they attempted to admit it. But I quickly looked it over and, somewhat to the surprise of the judge, did not object to its admission. Did not make any reference to the log until closing argument, then showed it to the jury and told them to look at it more closely. Officer A was not listed as working on the date, but the log also shows duty assignments for the officers working. Officer B is listed as being assigned to the evidence room or some such at the station, and Officer E is listed as being assigned to a patrol car across town with unrelated Officer F. Along with various other inconsistencies in the officers' stories, this led to a very speedy acquittal. Story 28. My grandpa has told me this story at least 100 times, but it's always entertaining. He was jury foreman for a harm trial in a small town in Tennessee. 2 guys got in an argument at a bar with the victim. The 2 guys drove home, got a rifle, came back, and shot the guy. Months later, while on trial, the 2 guys are getting hammered by evidence and eyewitness testimony. These guys were idiots and left a huge trail of evidence. While the trial is about to wrap up, with them going down for harm, the prosecutor brings in the final nail in the coffin, a surprise witness who happened to be the guy they had supposedly murdered. Those 2 idiots had shot and killed the wrong person, who happened to be in the wrong place at the wrong time, wearing the wrong clothes. Story 29. I was prosecuting a traffic ticket and ended my opening statement with something similar to, "By the end of the day, you'll agree that the officer caught the defendant going 65 in a 50. Defendant, representing himself, stands up and says, "While he may have clocked me going 65 in a 50. Judge stopped the trial, excused the jury, and was like, "You just confessed so. Are we changing your plea to no contest or what?" Edit. This is Texas, where you have a state constitutional right to a jury trial on literally anything. Story 30. Not so much a gotcha as it is the defendant giving themselves up. When I worked for insurance defense, I handled a fraud case where a man reported his Rolex as being stolen. He was adamant that he was at a hotel, and it was stolen. He has shown no proof of being in a hotel, so it's flagged. We go through the whole process, and finally reached depositions. He gets sworn in, and eventually let out that he wasn't at a hotel but rather with his mistress and he had left it at her house. His wife noticed he didn't have it on, so he immediately claims it must have been stolen, etc., etc. This man decided to hire an attorney and go through this whole circus, just so his wife wouldn't find out about the mistress. Story 31. I had a client who was accused of brutally harming a dog. Cop testified that there was no testing of the blood, no body ever found, and admitted it could have, in fact, run away. The eyewitness said she could see the harming down the hallway from the dining room. Cop testified there was no hallway and the dining room was on a different level of the house than the harming supposedly took place. Then the person who was leading the lynch mob against my client around town for the last year testified that she had been in the apartment between the two visits by the cop to evaluate the scene. No body, a compromised crime scene, witness who couldn't see anything, and admission that there was no proof the dog was dead. Closing argument lasted 3 seconds. Your Honor, I'm asking for an acquittal. Story 32. My client was riding his motorcycle on a relatively calm street when this guy exited his garage, without looking, and run over him. In deposition, the guy brought a witness that was with him on the passenger seat. The whole time, the witness maintained that my client was driving too fast, and that there was no time to brake the car. I asked him the same question a few times in different ways, making him tell the story again. In the fourth telling, he, already a bit frustrated, let it slip. Look, I've already told you. We were exiting the garage and, as soon as I lifted up from getting my cell phone on the car's carpet. Wait, so you didn't even see the crash? There was no coming back from that. Story 33. The plaintiff was being deposed in the lawsuit she filed alleging sexual discrimination. She was claiming her boss had made some inappropriate innuendos and overtures. The defense attorney asked her if, when the alleged statements or events took place, was she shocked? No. Was she offended? No. Was she damaged in any way? No. So why exactly are we here? Well, honestly, I'd rather not be. Meanwhile, her attorney stared straight down, scribbling notes, doodling. We ended the deposition there and asked her attorney if this was going away now. We got a call later, offering to settle for $1,000 and a letter of apology. Story 34. I was in a courtroom for a termination of parental rights case. The foster parent shared several observations of developmental and behavioral concerns after the child would have a visit with the biological mom. The biological mom's attorney got up after her testimony and asked the foster parent, "What professional credentials do you have to make these types of statements?" The foster mom says, "I'm an occupational therapist with the school district." Oops. He really wished he hadn't asked that question. Story 35. My wife is very much not a lawyer but owns some chump in small claims. Dude ran a garbage collection business, cheapest in town. We could see why when they didn't use a garbage truck, just some open-ended box truck the dudes manually dumped barrels/bags into. Anyway, driver pulls a 3-point turn and scratches up our steep driveway 3 times after a heads up the first 2 times, and witnessing the third. Leads us on for 6 months about repairing the driveway, only asked after third. Wife files, brings him to court, has all ducks in a row, full timeline and communications. Found out the dude was modulating our bill, and also literally didn't have a permit to work in town. Judge asks him if true. He says he didn't know he needed one. Judge sighs, says he's going to assume he'll get it tomorrow but make today's business right, and awards my wife 2.5 times claimed damages. But that's not fair. Cue the absolute roasting. Story 36. In court for a restraining order, my ex was adamant he had not nearly harmed our daughter, and that he did not in fact break into my house and point a gun at me the week prior. I was just a liar who wanted to keep his child away. When told I was asking for a full indefinite order, which is zero contact either, he said to his lawyer, "If this woman gets that order, I'm going back to her house, and I won't fail this time." Sadly for him, his microphone was still on. Story 37. Sued a former employer for $3,500 in unpaid wages. It was a slam dunk. Had a letter stating what my salary would be versus pay stubs that were less, in my opinion, so I didn't bother getting a lawyer to save on fees. Turns out the company thought they could try the same strategy. I show up to court, and the manager of the local office is there with an affidavit from the CEO saying he's allowed to represent the company in court. The judge asks him, "Are you an attorney?" "No, just an employee." A company can't have pro se representation. Judge immediately ruled in my favor. Felt really fantastic. Story 38. First witness testified that she saw the defendant shoot the victim. Second witness states the same. Police officer testimony is that he arrived at the scene and defendant was there holding the gun. The coroner's testimony described the sequence of shots and that the final one was fatal. Defendant yells out, "See, that proves that I didn't harm him. I only shot the guy twice." Story 39. Parent termination case I was prosecuting. Dad went on how he has changed his life around and worked the Alcoholics Anonymous program. Asked him what step he was on, and he proudly proclaimed 3. Asked him what step 3 is, he had no idea. Then asked him what step 2 was. Again, no idea. Parental rights terminated. Story 40. One time I was defending someone who was accused of causing whiplash after an accident. The person seemed shady, so while they were on the stand, I hurled my briefcase to the floor. They whipped their head around while wearing a cervical collar, and Peter was totally let go of the charges. Story 41. I was defending a client accused of stealing a high-end laptop from a coworker's desk. The prosecution relied on office security footage showing my client near the desk around the time the laptop went missing. During discovery, I requested the full, unedited footage. Turns out, the coworker had edited the clip to cut out a part where they accidentally left the laptop in a meeting room earlier that day. I played the full video in court, showing the coworker retrieving it later and claiming it was stolen. The judge dismissed the case on the spot. Story 42. In a contract dispute, my client, a freelancer, was sued for allegedly failing to deliver a website on time. The plaintiff claimed they lost business due to the delay and had emails showing my client missing deadlines. During cross-examination, I asked the plaintiff about their server logs, which they hadn't provided. I subpoenaed them, and the logs showed their own IT team had misconfigured the server, blocking my client's access for weeks. When I presented the logs, their attorney stuttered, and they settled for pennies. Story 43. I represented a tenant in a case where the landlord claimed they owed thousands in unpaid rent. The landlord produced a lease agreement with my client's signature, showing a higher rent amount than what my client paid monthly. I noticed the font on the lease looked off and requested the original document. Metadata showed the landlord had edited the lease after my client signed it. I showed the judge the tampering evidence, and not only was the case dismissed, but the landlord was ordered to refund my client's deposit. Story 44. In a driving under the influence case, the officer testified that my client was swerving wildly and failed a field sobriety test. The prosecution played dashcam footage, but it was dark and unclear. I asked for the officer's bodycam footage, which they claimed was malfunctioning. I pushed for the repair records and found the bodycam was working fine that night, but had been manually turned off. The judge inferred tampering, and with no clear evidence of swerving, the charge was dropped. Story 45. I was in a child support case where the father claimed he couldn't pay because he was unemployed and broke. He showed up to court in a flashy new suit and watch, which raised my suspicions. During discovery, I pulled his social media, where he'd posted about a side hustle selling luxury goods. I cross-referenced his PayPal records, which showed thousands in recent transactions. When I presented the evidence, he admitted to hiding income, and the judge ordered him to pay back support plus penalties. Story 46. In a workplace injury case, the plaintiff claimed my client's company neglected safety protocols, causing their broken arm. They had photos of the worksite looking chaotic. During deposition, I asked about the exact date of the photos. The plaintiff hesitated, so I subpoenaed their phone's metadata. The photos were taken months after the incident, during unrelated renovations. I showed the time-stamped evidence in court, and the judge ruled the claim was fabricated, dismissing it. Story 47. I defended a client charged with assault after a bar fight. The alleged victim swore my client punched them unprovoked. The bar had no cameras, but I interviewed other patrons and found one who'd recorded the fight on their phone. The video showed the victim swinging first and my client dodging before throwing a single punch in self-defense. I played the video in court, and the prosecution dropped the charges before the judge could even rule. Story 48. In a divorce case, my client's ex-wife claimed she deserved a larger share of the marital assets because my client was hiding money in a secret account. She had no proof, just accusations. During discovery, I found text messages she'd sent to a friend, bragging about stashing cash herself to get the better of him. I presented the texts in court, and her credibility collapsed. My client got a fair split, and her claim for more was denied. Story 49. I was prosecuting a theft case where the defendant allegedly stole jewelry from a store. They claimed they bought the items elsewhere and had a receipt. I noticed the receipt's store logo was slightly pixelated, so I contacted the store they claimed it was from. They confirmed the receipt was fake. Their system used a different font and layout. I showed the jury the real receipt template side by side with the defendant's, and they were convicted in under an hour. Story 50. In a medical malpractice suit, the plaintiff claimed my client, a surgeon, botched their procedure, causing permanent pain. They had an expert witness who testified the surgery was negligent. I dug into the expert's credentials and found they'd been disciplined for falsifying their experience in similar cases. During cross-examination, I exposed their revoked license and lack of expertise. The plaintiff's case fell apart, and the judge granted our motion to dismiss. This video does not promote illegal activity. Stories are shared for commentary and education.